The sirens didn't stop for nearly an hour. I can still smell it if I close my eyes. Burning insulation, wet cedar, something metallic in the air that didn't belong. Flames rolled through the attic like they'd been waiting for permission. When the first beam gave way, it sounded like a rifle crack. A firefighter grabbed my shoulder as I tried to step forward. "You can't go in there," he said, and just like that, 30 years of memories folded into smoke. By morning, all that was left was a blackened frame and a chimney standing alone. 48 hours later, before the fire marshal had finished his preliminary report, the HOA president filed an emergency demolition order. He called my home a community hazard, said it needed to come down immediately. Investigators were still sifting through ash. At the last HOA meeting, he'd leaned across the table and told me, "If you won't comply, we'll remove the problem permanently." Months later, we would see each other again. Only that time, I'd be the one behind the bench. But to understand how it got there, you have to know who I was before the fire. I was 46 when the house burned. Before that, I'd spent 12 years as a municipal compliance officer, the guy who read ordinances line by line and told cities where they'd overstepped. After law school, I moved into administrative law, still dealing in codes, procedures, timelines, not glamorous work. Mostly paper cuts and patience. I've been a widower for 5 years. Quiet suits me fine. The house was my father's. Cedar siding he installed himself. A wraparound porch we rebuilt one summer when I was 16. After he passed, I started restoring it the same way he taught me: slow, methodical, no debt if I could help it. Weekends meant sawdust in my hair and country radio drifting out of an old toolbox. The HOA didn't like that I refused their cosmetic suggestions. Paint color changes, decorative shutters not required by covenant, landscaping upgrades outside written authority. I don't hate HOAs. I hate overreach. There's a difference. To me, that house wasn't an asset. It was lineage. Nothing. Unsettled, secure power, more than someone who knows exactly where its limits are. His name was Randall Pierce. HOA president for 9 years straight. Real estate developer, the kind of man who shook hands too long and smiled without showing teeth. Every evening around 6, he'd idle through the neighborhood in a silver SUV, window down, phone angled, just right to photograph violations. Trash cans visible from the street, grass a half-inch too tall, a wreath left up past January. At meetings, he talked about protecting property values, like it was scripture. But enforcement had a pattern. His friends got warnings. Everyone else got fines. One night, he projected a photo of my garage siding onto the clubhouse wall. It was mid-restoration primed, not painted. I had a written extension approved by the architectural committee. I stood up and cited the bylaw. He leaned back in his chair. "Don't quote rules to me," he said evenly. "I wrote most of them. There were always closed executive sessions no one could attend. Landscaping contracts awarded to a firm that happened to share office space with his development company. An emergency powers clause buried deep in the covenants, rarely used, until it needed to be. From that night on, I wasn't just a homeowner. I was a problem that knew how to read. It started with envelopes, thin white ones at first, then certified mail slips tucked into my door. Daily violation notices for things that hadn't changed overnight. Improper material storage, unapproved exterior alteration, fines stacking at $50 a day, compounding like interest on a grudge. Then came the lien warning. Anonymous complaints followed claims of unsafe storage in my garage. Old lumber and tools, neatly stacked, suddenly labeled a hazard. A week later, a city code inspector knocked on my door. The complaint hadn't come through the HOA. It was filed directly with the city. That got my attention. My insurance carrier received a letter citing community safety concerns. My mortgage servicer got notice of alleged structural instability. Neighbors who used to wave started looking away. At meetings, questions about me were discussed in executive session. I documented everything, certified responses, dated photographs, timeline logs down to the hour. I recorded meetings legally, with notice. I wasn't guessing anymore. This wasn't random enforcement. It was coordinated. It was coordinated pressure. But I still didn't know who had pulled the city into it. And then he decided to say something he couldn't take back. That meeting was standing room only. I waited until the end, then stood and cited the state statute governing common interest communities, specifically the limits on architectural control and emergency authority. Calm. No theatrics. Just page numbers and language. You don't have unilateral power, I said. Not under Section 47F. Not without documented imminent danger. Randall didn't raise his voice. He leaned forward, fingers folded on the table. If you won't comply, he said quietly, we'll remove the problem permanently. The room went still. A few nervous laughs. No one met my eyes. 2 weeks later, my house caught fire. Investigators floated electrical as a possibility, but I'd passed inspection 6 months prior. Clean report. No flagged wiring. Before the fire marshal finalized anything, the board held an emergency vote, declared the structure hazardous, authorized immediate demolition. Urgency, they called it. I filed for an injunction the next morning. The court date came too late. By the time paperwork moved, excavators were already clawing through what was left of my father's porch. I stood there with ash in my shoes, realizing something hard. Grief can hollow you out, or it can sharpen you. The months after the fire were quiet. Insurance investigators came and went. I answered questions. I didn't speculate. I didn't accuse anyone in public. Grief is loud at first, but strategy requires silence. I started filing records requests instead. DAMAs between the HOA and the city's code office. Internal communications referencing my address. Documentation supporting the so-called emergency order. Bidding records for the demolition contract. Paper has a way of telling the truth if you let it. The contractor who tore down my house had prior development projects with Randall's firm. Not illegal on its face, just familiar. More interesting was the timing. The HOA's emergency filing was timestamped hours before the fire marshal's preliminary hazard assessment hit the system. How do you justify urgency before the report exists? Then there was the audio file accidentally included in a batch of board records. A partial recording from an executive session. Muffled voices. Laughter. A sentence cut off mid-thought. I set it aside. Around that time, I accepted an appointment as a county administrative hearing officer. Months later, I was elevated to presiding judge over municipal compliance matters. I said nothing about my house, and eventually, everything converged. It didn't start with me. Other homeowners had grown tired of the patterned selective enforcement, sudden emergencies, quiet coordination with city offices. Formal complaints were filed. The county opened an administrative review into procedural compliance between the HOA and municipal code enforcement. The cases were consolidated. By rotation, the assignment landed on my docket. There was a conflict check, an ethics review. My prior property loss was disclosed in writing. The panel determined the matter before the court concerned municipal process and statutory compliance, not my personal damages. Oversight safeguards were put in place. The assignment stood. The morning of the hearing, the room filled slowly. Homeowners on one side, city representatives near the front. Then Randall walked in. He didn't look at the bench at first. When he did and saw my nameplate, the color drained from his face. Just slightly. Enough. I didn't react. I called the room to order the same way I always did, steady voice, measured cadence. This wasn't revenge. This was procedure. And procedure, when followed carefully, has a way of unraveling everything. Testimony began with the city's code supervisor. Under oath, he admitted the HOA had contacted his office repeatedly the morning after the fire, emphasized community risk, asked for expedited handling. Their urgency, he said carefully, influenced scheduling priority. The demolition contractor followed. Yes, he'd previously worked on projects connected to Randall's development firm. No, he didn't see that as a conflict. Small industry, he shrugged. Then I admitted the audio file into the record. A partial executive session recording, authenticated through metadata and board disclosure logs. The room leaned forward as it played. Randall's voice, unmistakable. calm, confident. If the structure's gone, compliance solves itself. Insurance will clean up the rest. Another board member, hesitant. You mean legally? A pause, then laughter, low, uneasy. Silence settled over the hearing room like dust. Randall claimed it was taken out of context, a hypothetical discussion. Poor phrasing. Next, I displayed the timestamps. The HOA's draft emergency hazard declaration was created hours before the fire marshal's preliminary assessment was uploaded to the system, not proof of arson, but proof of intent to act first and justify later. The pattern was procedural manipulation, coordinated pressure, bad faith use of emergency authority. My ruling addressed only the law before me. The emergency order was improperly issued. Conflict of interest violation was established. The matter was referred for state ethics review. Civil penalties imposed. The HOA's ability to levy special assessments was frozen pending oversight. No raised voice. No commentary, just findings. And findings carry weight. The ruling didn't end Randall's problems. It started them. Within weeks, the state licensing board opened a formal inquiry into his development disclosures and vendor relationships. The questions weren't dramatic, just precise dates, contracts, shared office space, overlapping signatures. My insurance carrier, armed with the administrative findings, intensified its subrogation review. Attorneys who had once moved slowly began requesting depositions. Inside the neighborhood, something shifted. Homeowners who'd stayed quiet during the fines, and letters started asking for financial records. A special meeting was called. Votes were counted twice. He was removed as president by emergency motion. The local paper ran a modest headline: HOA emergency demolition ruled improper. Not front-page news. But enough. A week later, Randall resigned from the board entirely, citing personal reasons. There was no perp walk, no handcuffs, just the steady erosion of influence. Power built on shortcuts rarely survives sunlight. I never raised my voice. I didn't have to. And once the dust settled, the neighborhood faced a choice about what came next. The rebuild started the way the original restoration had: slow, deliberate, documented. Insurance paid what it owed. A civil settlement covered what it didn't. Every permit was pulled, every inspection scheduled. I followed the code the same way I always had. Not to prove a point, just because that's how it should be done. But rebuilding the structure wasn't enough. A new board was elected, and I agreed to help draft amendments, clear open meeting requirements, mandatory conflict disclosures, written standards for invoking emergency powers, and formal audit rights for members. Nothing radical, just sunlight where there hadn't been any. The tone in the neighborhood shifted. People started waving again. The day the framing was complete, I stood where the old porch used to be and planted a young oak near the steps. They thought removing the structure would remove the problem. What they removed was their own protection from the law. If you've ever dealt with an HOA that forgot who it works for, you already know why this matters. Let me ask you something. Have you ever seen an HOA suddenly invoke emergency powers when it was convenient, when due process would slow them down? Have you watched rules get bent just far enough to pressure someone into backing off? Be honest, would you have stayed and fought the way I did? Or would you have walked away and called it peace? And here's the bigger question. When board members abuse authority, should they face personal liability for it? I read your comments. I pay attention to the patterns because this isn't rare. In the next case I'm covering, an HOA tried to foreclose on a homeowner over a $312 landscaping fine. What they didn't realize was that he had federal jurisdiction on his side, and that changed everything. If you believe property rights still matter, subscribe. There's more coming.